Motion to enter adjudication of guilt and revoke community supervision, and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney. Did you understand it? Right. Hello, Mr. Hogen. All right, why is your daughter not with us? I'm used to seeing her now. Is she back in school or studying?
You need to talk to her. She took the LSAT.
Yay.
Giving up to taking a different. I'll tell you something. I think she did great, but she for the stars.
No, because do they still do that? I remember they said if you took the LSAT and then you did another one, then they would just average it. You can't just say, they don't do that anymore? Oh, you can take it as many times as you want to?
You can only take it 5 times.
Oh,
I'm not up on the rules, but I know the rules have changed.
I challenge all of us to take the LSAT again. It'll bring back memories.
The hearing begins quietly, but the tension is already building. The judge opens with the motion to revoke community supervision, a serious moment that could decide this man's freedom. She greets Mr. Hogen with calm authority, even asking about his daughter, a brief human touch before diving into legal gravity. But beneath that politeness, you can feel what's coming. This isn't going to be an easy session.
Bad memories, right? All right, so on this case, are we here on a motion to revoke? What are we here for?
We are, Your Honor. We're here on a motion to revoke, and I believe the state filed a motion to amend the motion to revoke, and it was filed on September 29th. Yesterday.
All right, just 1 second. Okay, there's nothing attached to this.
They said that the DA's printer hasn't lost ink and it was emailed to them.
I'll accept, I'm fine with service by email, if that's okay with you.
Okay, all right, thank you.
I wrote it on there too, Judge, email to the best guy.
All right, thank you.
We're working on getting the ink restored.
All right, thank you.
Hard time for the county judge.
All right, thank you. And then on Hogen, I don't have the motion to revoke file. Hogen. Oh.
Should be printed out there.
Right, all right.
As the discussion shifts to the new motion filed just yesterday, confusion spreads. Papers aren't attached, files are missing, and even the DA's office blames a printer running out of ink. The judge's patience stays steady, but you can hear the disbelief in her tone. This isn't just paperwork. Someone's future depends on every line of it. Have you ever seen a courtroom moment where small mistakes caused big consequences?
And so it's set for today. And what is the issue?
Your Honor, the first amendment was filed yesterday. This is the first chance I've had to get to talk to my client. I was wondering if I could have some time to prepare him and talk to him about this case.
All right, do you have the original motion to revoke? Because I only have the First Amendment. Where's the original?
Would a copy suffice?
Rashad is bringing it.
Oh,
Thank you. We made it. So the only thing that I see that's been added.
Here's where things heat up. The defense lawyer admits he hasn't even had time to fully prepare his client. And that's a red flag. Then the judge spots something off. A new charge of possession of a controlled substance without any lab results to back it up. She questions why it's even there. The room goes silent. It's a reminder. In court, evidence isn't just important. It's everything.
It is a possession of a controlled substance.
Yes, Your Honor, that's one of the new number one.
All right, do y'all have labs for that?
We do not, it just occurred.
Then labs, are y'all expecting to have those labs in 10
No,
minutes?
I told counsel, there's no way we'll get those back anytime soon.
So then the First Amendment really has no bearing because they're not going to be prepared to proceed on the violation of condition of number 1, possession of a controlled substance. So I don't know why it was added. They don't have any labs for that. They're not going to have labs for that. And it'll probably be 6 months or whatever before they get labs for that. So really the only thing that's going to be proceeded on is probably the original.
the original.
Yes.
Can we on that right now? Yes.
Stay.
May I see the?
Yes. And just mention the one thing.
Sure, Your Honor, yeah. Just so the court knows, on the original, the other new number one, the evading, was dismissed by our office, so literally the only thing left is the number two.
Can I have a file stamp, please? Yes. So is this a case that criminal trial division or
The judge's logic cuts through the confusion. Without lab reports, the new charge doesn't hold. So, the case will move forward based only on the original violation. You can almost sense the prosecutor's unease. Their case just got weaker. It's a small victory for the defense, but the storm isn't over yet. Do you think the judge made the right call here?
is family violence going to handle? Because there's nothing that will be left in here that is criminal trial division. The evading has been dismissed.
Your Honor, my understanding before that was the discussion is that we were going to handle it, but I haven't conferred with family violence since.
All right, if you want to confer maybe with family violence, because it appears that the only thing on this motion is going to be failure to submit.
And we're gonna plead truthfully.
Okay. So I don't know if who's going to be making the recommendation on their side.
Your Honor, I'll proceed on.
All right, the court is calling 2024 CR 0077778 State versus Christian Grant Hogen. Can I have parties announce?
Melissa Alvin for the state.
And Eric DeWalt, I represent Mr. Hogan.
And are you Mr. Hogen?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Christian Grant Hogen who was placed on deferred adjudication in 2024 CR 0077778 for the offense of assault family household member impeding breath or circulation on October?
Now the case is formally called State versus Christian Grant Hogen. The judge reads the charges, the 2020 deferred adjudication for assault involving family violence. When asked how he pleads to the new violation, failing a drug test, Hogen says true. That single word changes everything. You can feel the courtroom tighten. The judge now has full authority to sentence him to up to 10 years in prison.
October 31st, 2024 for a period of 6 years. Is that you?
Yes, ma'am.
All right, state.
You can proceed on number two, Your Honor. On or about the 15th day of August 2025 in Bexar County, Texas, the defendant, Christian Grant Hogen, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number two.
How do you plead to that? True or not true?
True, Your Honor.
State.
We'll waive the rest, Your Honor.
Any objections to the waivers?
No.
Did you understand by pleading true to violation of condition number two, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
May I speak on that?
No, my question is, do you understand
Yes,
that?
ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number two? Court will find violation of condition number two true. Is there a proposed agreement?
My understanding is there is not, Your Honor. The state is recommending that we follow the probation department's recommendation, which is to have the defendant submit to SATIF, withdraw the MTR and alter and amend his conditions for SATIF.
All right, so the MTR can no longer be withdrawn because he's
Oh,
already played.
That's right, Your
So-
Honor. I apologize.
No
But,
problem.
That's what we would recommend, is that he go to SATIF.
All right, so defense, what are you requesting?
Your Honor, exactly that. I just spoke to my client. He was under the understanding that he had a possession of drug paraphernalia when he did complete SATIF and does have a full-time job and understands he's going open to the court. He missed this one drug test because he couldn't get there on time. He has drug tested before and they've all come out negative. This is his first MTR. He seems to be doing very well on the deferred adjudication. He understands he's up in front of you with the full range of punishment and kind of going open to the court. But wanted to address the court and ask that if he could have a less.
But something unexpected happens. The defense steps in, asking for leniency. Hogen, they explain, has a steady job and has passed all other drug tests. He only missed one because he couldn't make it on time. The judge listens, expression unreadable. The moment hangs heavy. This is where justice and mercy collide. What would you do if you were the judge here? Show mercy or enforce the law strictly?
Structured modality that he could continue to work.
All right. Before you address me, any objection? I haven't opened it yet, but any objection to the court reviewing the court summary? All right.
Next. Or do you?
Oh, yes, they emailed me.
Okay.
I receive it by email, but I don't open it until parties have no objection. All right, probation. What are you recommending?
The recommendation is for residential treatment at SATA followed by the aftercare and continued on the ISD case.
Is it possible to do just do the aftercare portion, or has the time frame between being in SATA?
Well, he didn't do SATA the first time, Judge. He did local ISF.
Okay.
So as we know, local ISF is more geared to cognitive, and then the SATA has that substance abuse. I was in the midst of looking up why he did not qualify for a drug court. If you would
Yes.
like to know that.
Yes. And then you want to raise your right hand for me?
Yeah.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Christian Grant Hogen.
All right, so it appears there's something you wanted me to
Yeah.
hear. Did you want him to speak to me, counsel?
That's his intention. It's your intention.
The probation department steps up with their recommendation, a full residential treatment program. Then Hogan himself speaks. Nervously, he admits his mistakes. Homelessness, losing his belongings, struggling to stay in touch with his probation officer. He's not making excuses, just explaining life as it really is. The judge listens closely. This is raw humanity on display, and you can feel the emotion rising.
To address the court.
Yeah, no.
Yes.
I just want to let you know, ma'am, I understand this, what they're recommending. I just feel like, and it's been fair since I've been in your courtroom, ma'am. I already completed ISF, which is.
So here's the thing. Let's get to the crux of the problem.
Yes,
The
ma'am.
problem is you didn't report for your UA. Why?
One time, ma'am, I was
No,
there.
no. Let's not do the one time.
well,
Because
I'm
one
saying
time
what-
is enough. Wait. We have to speak one at a time. And so let me explain something to you. So don't tell me it was only one time. And the reason why I tell you not to tell me that is because those are conditions of your probation. One time for anything is enough for you to be revoked and sent to prison. So don't say it was just one time, because that's making excuses, right? Just tell me, why didn't you report?
Well, when I first got out, ma'am, I'm gonna get to that. I was doing well. I was remodeling homes with my brother, and I was always in contact with my probation officer, and I had just lost my efficiency, ma'am, and so being in the streets, having my things stolen, lost the storage, and so and these are not excuses, ma'am, these are the truth. I had trouble with cell phone, and I always made sure I emailed when I didn't call her, and so fast forward to the motion to revoke. I had just over there, I want to say 7 days prior to the motion to revoke, because I hadn't been able to speak to her, and that's the reason why I missed it, because I'm having to deal with wanting to get shelter, and I was living in Fishing, and I went to the hotel, and it was just hard, ma'am, and that's just all I can tell you.
Here's the thing. I'm going to give you a choice. These are your choices. There's no other choice, right? Here's your choice. I can revoke you and I will sentence you to 2 years in the prison. That's one choice. Or either your second choice, I will continue you on probation. And what I'm going to do is it's going to be an intensive
But the judge draws a hard line. One time is enough, she says firmly. Her words slice through the air. No excuses, no shortcuts. Still, she offers him 2 clear choices. Go to prison for 2 years, or stay on probation under intensive supervision with GPS monitoring. It's tough love delivered with precision. The entire room knows. This is her way of giving him one last chance. Do you think he deserves that second chance?
Supervision. And I'm going to start you off with GPS, and that will be partial GPS for employment only. Those are your two choices. There are no other choices. Do you need to discuss that with your attorney?
No, ma'am. Could you please waive the fees on the GPS?
Yes.
Yes, ma'am. I can do it. I can do it, ma'am.
All right, Ms. Abrams,
Thanks.
I'm going to deny the motion, alter and amend conditions to include partial GPS for employment only, waive fees, and intensive supervision with probation and intensive outpatient treatment with probation. Is there anything else?
Nothing from the state, Your Honor.
Ms. Abrams, is there anything else?
No, sir.
Anything else you need from the court to be successful?
You don't know everything is what.
You're welcome. Anything else?
Can I just clarify, he's on deferred adjudication, correct?
Yes. All right, thank you.
Judge, thank you for all your consideration.
You're welcome.
Appreciate
You're
it.
welcome.
Finally, the judgment is made. The motion to revoke is denied, but new strict conditions are added: GPS tracking, intensive probation, and outpatient treatment. Hogen quietly agrees, relief washing over his face. The judge's tone softens as she concludes the session, showing both firmness and fairness. In this courtroom, justice didn't just punish, it also tried to rebuild. Final commentary and call to action: what a journey! From confusion over paperwork to a powerful decision of accountability and compassion. This case reminds us that justice isn't only about punishment, it's also about understanding the human story behind every mistake. The judge balanced authority with empathy, and in the end, a man walked out with one more chance to change his life. What do you think? Was the judge fair or too lenient? Drop your thoughts below. And don't forget to like, share, and subscribe for more real courtroom breakdowns where every decision tells a story.